All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Pierre presiding, is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. You'll see there's only two of us up on the bench this morning. Judge Myers is unavailable. She will be watching the proceedings from YouTube and will take part in the decision. So we have three cases this morning. The first is Sauders versus Sauders. Counsel may approach. All right, Mr. Sauders, you have 15 minutes to argue your case. You may approach the podium. You may also reserve time for rebuttal if you would like to do that. I'm sorry, I had you both backwards.
Your Honor.
Would you like to reserve any time for rebuttal?
No, Your Honor.
Okay.
What brings me here today is that mostly the love for my children. I love my children very dearly, and on June 10th, 2016, the rights to those were removed from me, and for multiple reasons, but the reasons required for me to get custody back of my children were set forth in a decision by the trial court, and that was on June 10th, 2016. And the requirement was that I would receive a mental health assessment before I did any kind of filing to regain custody or any adjustments to that custody. On July 11th, 2021 of last year, I filed a motion for change of parental rights and responsibilities with the trial court. I filed a mental health assessment from the Veterans Administration titled as Exhibit B within that motion. But
there seems to be some dispute as to whether that was actually an assessment or not. Could you address that?
I went to the VA, and they literally, I sought a mental health assessment, and it says mental health assessment on the VA document, and they did a full assessment. I mean, I believe it was 20, 30 pages long on my full mental health history, all the way ranging from childhood to current. Including everything from PTSD, from being a law enforcement officer, all the way through. And that is the dispute. I don't know what else that I could provide that would be more thorough than that. I've rejoined the military. I've received multiple mental health assessments there by military personnel. Even one of the state's top personnel, Colonel Kathy Potoni, gave me a mental health assessment to become an officer in the state military.
Mr. Sauders, let me ask you, what we have here appears just to be a summary. You said there was a 30-page mental health assessment that you filed.
Let's see. This is the summary, yes, okay. Pretty much, of that assessment.
Did you file the 30-page report with the Domestic Relations Court?
I just filed the part that's the page for the 7-page assessment that they summarized out. I guess they conglomerated into one.
All right.
So, but this is the 7-page assessment that came out of the VA on December 11, 2020. Yeah, so general medical pharmacy, or general psychological medical pharmacy assessment is on page 4 of that in the VA notes.
Okay.
And given to that, honestly, my mental health, it was when it was in question. I was never a harm to my children. It was more of a situational depression for my divorce. I was going through a hard time, and it continuously just got worse as I went. It was not something that was permanent psychological that I was going to be enduring for the rest of my life. It is something that I could overcome, which I did. And I've done a great job doing that. I've supported my children. I love them. I attend as most sports games as I can. I probably take them to about half of their sports games. And truly, for all things considered, even though we are here, their mother and I, for our issues, we do co-parent quite well and coordinate that quite well. I'm not here to bash her. She's a great mother. She loves the children. We just have a disagreement on the amount of time that we should have with them. And that's all I have.
Okay, thank you very much.
Thank you.
Mr. Morris?
Thank you, Your Honor. May it please the court, Tim Morris representing Mother Tiffany Sauders. Your Honor, a couple things. Number one, there's two parts where this motion should be denied and dismissed in its entirety. The first is that clearly father did not follow through with the recommendation of the Parental Services Department, the social worker back in 2016. If you read that decision, that Parental Services Department social worker said that father should have a drug assessment and a mental health assessment at that point. He never did that, but the judge, for efficiency's sake, I assume, moved forward with that and made an order and made it very clear. If you come back to this court, you need a full mental health assessment. That's not what happened here. Mr. Sauders had mental health issues going back to that 2016 entry. Substance abuse, mental health assessment. The court presumed drugs were present because he refused to get a drug test. He has mental health questions, does not provide stability for his kids. So there's a lot of those red flags back in 2016. They say you have to get a mental health assessment. In addition...
And so he said he did, and it was like 20 or 30 pages.
And of course, he never filed that. He never gave it to me. He never showed mother. But back in 2016, the court said that he's got chronic anxiety and depression, which he's been receiving treatment. And that's all this assessment was. If you look at the assessment, it says, quote, Mr. Sauders is a 36-year-old male with a history of depression who wanted his psychiatric medications to be reviewed. That's all this was. This was a review of his medications. He's been on medications for quite a long time. Prior to 2016, comes to try to modify the order, gets his medications reviewed. That's not a mental health assessment, but that's only one piece of this, Your Honor. He clearly asked for custody. He asked for custody in the title. It even says a modification of parental rights and responsibilities, custody. It then says, now comes Stephen Sauders, the move-in, requests a change of allocation of parental rights and responsibilities, custody. As this court's well aware, to get a change of custody, you have to, the court, there shall be a change of circumstance. If nothing of slight, it has to be something of substance. Mr. Sauders listed 5 things of change on his motion. All 5 were for his change. The non-residential, the non-custodial parent. That does not suffice to get over that hurdle of a change of circumstance. So the court dismissed this on its pleading for 2 reasons. One, there has been no change in the custodial parent or child's life. He didn't even allege any change. Number 2, he didn't do the mental health assessment as required by the court. For those 2 reasons, either one of those, and both those reasons, the court denied it and dismissed it in its entirety, and we're asking this court to affirm that.
Okay.
Thank you.
Thank you. Mr. Sauders, you do have a few minutes for rebuttal if you care to. If not, that's fine.
I will.
Okay, sure.
Yes, Your Honors. I did, in regards to the notification of the children's mother, this mental health assessment, she was provided it before any court proceeding was ever initiated. I gave her this to try and prevent any of this, so maybe she would take that into consideration. That has not occurred. As far as my living conditions in 2016, they were not bad then, and really now she filed a complaint and had Butler County Jobs and Family Services come out and do a full assessment inside my own home. So, and they declared that there should be no issues with either one of us as parents. So that's already occurred. So I don't know what else could be done. We've had people come to the house that have said, your home is okay, you're both are good parents. I just want the same rights as she has, nothing more, nothing less. I love my children. They love me. And that is all.
Okay, thank you very much for your arguments. We appreciate the arguments of both parties today. The case will be submitted and we'll get out a timely written opinion. Thank you both and have a great day. All right, the next case is State versus Fuqua. Morning, Ms. Nelson, Mr. Donovan. Ms. Nelson, how much time would you like for rebuttal?
5 minutes, please.
5 minutes. You may proceed when you're ready.
Thank you. Good morning, Your Honors. May it please the Court. Good morning, Mr. Donovan. Sarah Nelson here on behalf of Mr. Ricardo Fuqua. There's two issues that I want to discuss this morning, probable cause to arrest and sufficiency as it relates to the element of operation. Regarding probable cause, it's our position that this was an illegal arrest because there was insufficient probable cause supporting intoxication. In Cleveland v. Gearing, the 8th District says that the indicia of alcohol use, so the odor of alcohol, glassy eyes, slurred speech, things that indicate that somebody may have been drinking, they're not enough. It's insufficient to constitute probable cause. We need something else to elevate reasonable suspicion, which indicia of alcohol use would support, to elevate that to probable cause, which we don't have in this case.
Well, what about the car being kind of stopped at a stop sign? I mean, that seems to be circumstantial evidence, at least, that the car was in motion and came to rest at a stop sign. How is that not sufficient?
So I don't think the record supports that the car was in motion to get to that point. I think that we have evidence that the vehicle was parked at the stop sign, but was it parked before or after use? There are plenty of residential...
Well, but we did have a case that I think is up at the Ohio Supreme Court right now where there was a vehicle that was parked on the side of the road across the street from like the person's house, and the people were in the vehicle and there was no evidence that the vehicle had actually moved. I view that as at least potentially different than this situation where there was testimony that this was in the road as opposed to on the side of the road. And so it had to get there somehow, right?
I agree.
So I mean, do you see the distinction I'm drawing?
Yes, I do. And I agree. I think, so where I'm coming from, I guess, in my view of the situation is that there are certainly residential areas where you can park up to the stop sign. And there's no evidence in this case that this was one of those neighborhoods where there was a yellow bar that says you have to be so many feet away from the stop sign. So that's where I'm coming from when I think we can't assume that being parked at the stop sign in this case was a situation where he had moved the car to get to that point, or he simply just parked there. We know that he was at a friend's house and was leaving his friend's house on his way home, but was his friend in that neighborhood? Where are we in the time frame here of getting back into the vehicle after this alleged use of alcohol or drug of abuse? So that's, in our view, we don't have observation here of actual movement, which is significant. We just have some car parked at a stop sign. The officer did not cite a traffic violation. He acknowledged that. He concedes that it wasn't in his report. So in our view, there was no traffic violation with respect to where he was parked. There was no tow, and I think that the fact that there was no tow, that's something that the state could have used to prove that this vehicle was in fact obstructing traffic. We also have to consider the snow element in this case. There's certain times where it snows so badly that you can't actually get all the way over to park your car in a position where it's not totally free. In a residential neighborhood, we have some tight streets here. So for those reasons, these are factors that the state could have elicited from the officer, and they didn't in this case, which is why...
You were speaking to probable cause, but you left out the part about your client being passed out in the car and the officer not being able to rouse him. He had to actually open up the door. When your client was able to get out of the car, he almost fell over, and the officer had to support him so he didn't fall. And he admitted having 4 drinks. So should that go into our calculus of probable cause to arrest here?
I think all of those factors go to suspicion of use, alcohol, indicia of use of
We admitted
alcohol.
4 drinks. He didn't say what it was, but he had 4 alcoholic drinks apparently.
Yes, and the officer didn't question him about when those drinks were consumed, and in some cases, that's a significant omission by the state. He could have had 4 drinks 4 hours ago. We don't know that, which is why, again, I think it all goes to reasonable suspicion. It doesn't elevate to probable cause in this case. Those are significant factors, but again, we don't have enough here to elevate to probable cause. And I was blurring the lines here between probable cause discussion and the sufficiency issue, because they are kind of intertwined. But just to reiterate, I think the Anderson case, State v. Anderson that I cited, where the car was parked in a parking lot, obviously he had to move the car to get to that point. The question is, did he move it while he was intoxicated getting to there? Or was he parked, used drugs in the parking lot, and was just in the vehicle under the influence? Again, I think the case law is pretty clear that the law doesn't prohibit somebody from using a vehicle as a heated hotel room, which is pretty much, in our view, what we have in this case. So if the court's not inclined to reverse on the probable cause issue, then we would ask to reverse and discharge him on the OVI offense, remand for this to be a physical control case only. Thank you.
Thank you, Ms. Nelson. Mr. Donovan?
Good morning, Your Honors. Pardon me. I guess I can start where Ms. Nelson started, which is operation. The officer testified that the vehicle wasn't parked, that it was stopped. He was very clear about that on cross-examination when counsel had said, well, it was parked here at the stop sign. He said, no, it was stopped. There's testimony that the snowplow driver had reported that other vehicles had to go around it, that he had to go around this vehicle, and the officer, upon arrival, testified both at the motion and at the trial that he had observed vehicles having to go around it. The vehicle was stopped in the travel lane. It wasn't parked off on the side of the road. And the fact that no citation was ultimately issued does not mean that there was no violation that was committed. That's not necessary. That doesn't change whether or not a violation.
And Ms. Nelson raised the point of, sometimes you can't get over to the side of the road if there's a bunch of snow accumulated or something like that. Is that the state's burden to establish that's not the case, or is it the defense burden here?
But if he couldn't have gotten over to, I would say that would actually, work in our favor in terms of if he couldn't get over because of the snow that was there and had to park in the street, then that's indicative of operation, and then that would be another circumstantial piece of evidence that would say operated the vehicle. This is akin, as the court was mentioning, a car that was parked. I believe in that case, and that might actually have been one of mine that I think I lost. The officers.
Supreme Court may vindicate you.
Anyway, moving on. There was no indication in that case that the vehicle had ever been moved. It was parked out in front of a residence. They were responding to a domestic violence call or a domestic incident call. And ultimately, they ended up arresting because the individual was intoxicated, but none of the testimony supported anything. Here, that's not the case that we have. We have the car stopped in the travel lane. Ms. Nelson says the car wasn't towed. I don't believe that it's actually clear from the record what happened to the car. I think everybody kind of forgot about the car, and I don't believe the officer was ever asked as to whether it was towed or what happened to the vehicle. I find it hard to believe that it was left in the middle of the street, but I don't think that the record indicates one way or the other what ultimately happened to the vehicle that day. So in terms of operation, I think this is much more akin to the vehicle being found on the side of the road. Mr. Fuqua was in the driver's seat, cars running. There was some confusion initially as to whether it was in park or in gear. I believe that it was ultimately testified that the car was in park at the stop sign in the travel lane. I believe that demonstrates that it was operated at some point in time in terms of impairment, all the efforts that he had to take to wake knocking on the glass, shining the light in there, yelling, opening the door, snow's coming in, continuing to yell, having to physically shake. And then Mr. Fuqua was extremely disoriented and confused. That was the testimony. Had difficulty understanding the command to get out of the vehicle, that it took him a minute to get out of the vehicle and needed help to get out, admission of alcohol. All of these things, the court is well aware of the standard for proving an OVI in this context. And I would just remind the court that just because there is a possible individual innocent explanation for each thing, that doesn't mean that the trial court had to, or in this case the jury, had to accept that innocent explanation. They were free to reject that and to use these items as indicia of impairment, which by finding him guilty, they clearly did. If the court has no further questions. Thank you.
Thank you. Ms. Nelson, rebuttal?
Just briefly, I think it is a significant detail how the car was parked, and any omission as to facts relating to how the car was parked should be construed against the state. It should be the state's burden to prove how it was parked, whether or not a tow was viable, things like that. So it gives the fact finder a clear understanding.
But what about what Mr. Donovan was indicating, that there was the call from the snowplow driver, and then there was some testimony about like cars having to get around it, which suggests it's not just on the side of the road, but actually in the road.
So
Why isn't that enough to establish operation?
Well, again, if a car is parked in a residential street where you can park up to the stop sign, cars are certainly going to have to maneuver around it regardless of it having been moved to that position in an intoxicated state. Same situation with the snowplow driver. I don't think it moves the ball here toward the movement goalpost, if you will, because it's hard for a snowplow to navigate a residential area regardless. I think if the snowplow driver would have come in and testified to what exactly he observed, we would have a different case. If the officer had given us more detail about the circumstances surrounding how the car was parked, similar to the cases that are cited throughout Anderson, was it, those cases go into detail about how specifically the car was parked. Was it up on the median? Was it up on the curb? Was it parked at an angle? Was the turn signal on while he was at the stop sign? If the turn signal was on, certainly we have circumstantial evidence that he moved toward the stop sign. We're at a T intersection. He had to go left or right. Those are the type of factors that I think the case law demonstrates are necessary to support the finding of movement, which we don't have in this case. We have to sort of assume facts that are not in evidence to support the state's position. If there are no further questions, we just ask that you reverse.
Okay, thank you. Thank you both for your arguments this morning. The case will be submitted, and we'll get out a timely written opinion. Hope you both have a great day. All right, the final case on the docket is State v. Wilson. Morning, Ms. Steer, Mr. Hoffman.
Morning.
You may approach. How much time would you like for rebuttal?
Your Honor, I'll reserve 5 minutes.
5 minutes.
I'm fairly certain I'm not going to use it. Good morning.
Morning.
Counsel, may it please the court. In this case, the trial court improperly dismissed the charge against Courtney Wilson. He was charged with sexual imposition. In December 2020, he was arrested in, I believe, August of 2021. The trial court dismissed, only saying that he found that there was no reasonable explanation for the delay in serving the warrant on Mr. Wilson. And he said, therefore, that's why I'm dismissing. By doing that, he didn't look through the factors for constitutional speedy trial that are listed in Barker versus Wingo. And in my brief, I go through all of those. I just wanted to take the opportunity to answer some of the things that were raised in Mr. Wilson's brief. As far as whether or not the state had to ask for any findings of fact or anything like that, the trial court was clear what its decision was. Again, it was based on the whether there's reasonable diligence. Here there was.
Can you answer the question of, was there an actual statement by him? There seemed to be some confusion, at least from my perspective in the briefing on that.
That was going to be my next point, Your Honor.
Okay.
In the appellate brief, the defense counsel suggests that maybe there had been some earlier contact with Mr. Wilson, either before the warrant was issued or shortly after. But I went back and looked at the motion to dismiss, which is trial document 9. And in that, the defense counsel said Mr. Wilson was unaware of this charge pending against him for 265 days. I'm fairly certain that what was provided in the discovery, as this court knows, when what shows up in the record is what's given in discovery is just the cover page, and it just said a statement. I'm fairly certain what was provided was a statement that was made either after he was arrested, or it might have been something that happened afterwards. But so that statement had nothing to do with.
Yeah, because I just got confused. Like, if he gave a statement, like,
Right.
didn't they have him, there, and couldn't they figure out?
And there's simply no evidence of that. And so I think, given that, there's just there was no evidence of any prejudice. When you look at the factors that are listed in Duncan, clearly oppressive incarceration, he was not incarcerated while they were waiting to serve the warrant. Whether or not he gave a statement before that kind of went to the anxiety. The second element that's listed in Duncan, it's clear from what his counsel said in the motion he was unaware of the charges. And so then the only thing that it could be would be whether or not the defense was impaired, and there's just simply no evidence of that. In that same motion to dismiss, trial counsel said witnesses have moved, memories have faded, video footage has either expired or been deleted. But again, this was allayed during the hearing when Detective Brown testified that he interviewed everybody on camera. It's either on his body-worn camera video or at the station video. He testified on page 7 of the transcript that nothing had been lost and that all of it was still available. So there's just simply no indication that defense was impaired. So unless there are any other questions, we would ask that the court reverse.
My only question I have, ma'am, is what are you looking for here if we were to reverse? Do you want it remanded for another hearing, or do you want, since this is a de novo review, do we review the transcript and make our own decision?
I think based on Duncan that you can review and make your own decision since it is de novo, and I think that the record's pretty clear that there is no evidence. So I would ask that the court reverse and let it go forward on the trial rather than remanding for a new hearing on the motion to dismiss.
Well, and it sounds like this is, if this ever were to go to trial, it would be Mr. Wilson's word against the victim, because it sounded like at least the brief facts that we have that it's just two people involved.
That's my understanding as well. I think that there's a Marison report from the victim and then
You're right.
her statement.
Okay.
Thank you.
Thank you.
Thank you. Mr. Hoffa?
Please the court, Ms. Steyer. Between briefing and argument, sometimes it becomes apparent when a party when you fail to hit the nail exactly on the head. And I think that although I did make the observation in this case that the attempts to contact Mr. Wilson took place before the filing of the complaint, I failed to appreciate the significance of that. There are two things about that are very important to this case. And the first one is that because those attempts were made prior to the filing of the complaint, those attempts were not attempts to serve a complaint. Those attempts were attempts to investigate, to get a statement from Mr. Wilson, to further promote the case. Both of them were.
Well, or if they'd contacted him and made a statement, maybe they would have never filed these charges.
Or maybe they might have filed them. I don't know. But the point I wanted to make is that if you're looking at attempts to serve the warrant, those two attempts were not attempts to serve a warrant. Those were attempts to contact my client to get a statement from him. And that's important because
But I'm wondering, I understand the distinction you're making, but if they took those measures were unsuccessful, like, why would they need to, do that again after they have the criminal complaint?
that's what I was thinking too when I wrote the brief, but it throws you off to think that way. Because the importance of no, with respect, I mean, I didn't mean to say you were being thrown off, but you see, there are cases, a line of cases that say that if there's no activity at all to serve a warrant, you don't have to prove prejudice. There's there's Sears, Jackson, and Pierce. In all those cases, the degree of delay was, varied. And there were some attempts in some of those cases, but this court just decided not to recognize those attempts to serve the warrant. And the rule is on those three cases, if there's no attempt to serve a warrant, there's no need to prove prejudice. And this morning I want to say that in this case, you don't have any attempt to serve the warrant. Those two attempts were attempts to investigate. They were not attempts to serve the warrant. And then that's number one. Number two is, this is under the Sixth Amendment, and under McDonald, you only count the delay from the filing of the complaint. In this case, if you'd count that pre-accusation delay, you'd have another 3 months because it was September when the allegations. And so if you're not going to count that for purposes of delay, but you're going to count those attempts, those pre-accusation attempts. I mean, there's no symmetry there under the Sixth Amendment analysis because everything begins at the filing of the complaint that you look at. So those are the two reasons why, and I missed it in the brief, but I think those are two good reasons.
But I mean, getting back to the question I started with, like, if they take those efforts and they're completely unsuccessful, are you saying they have to repeat those efforts even knowing that they'll be unsuccessful a second time to avoid this, to avoid that being held against the state?
Here's what I'm saying. If they run into trouble contacting him, if they were unable to contact him before they file a complaint, then they would do like if I have a client I can't get a hold of and I have to file a brief for him, you put a stickum on it and you call an investigator, you do something else. You try to, you even put more effort into it because of those failures. It doesn't excuse the lack of attempts after the filing of the complaint. What it does is it's an indictment against them because they should have known they had to try harder because they couldn't get a hold of them in the first place. So if there are no further questions, I'd ask that this court would affirm for the reasons I forgave. Thanks.
Okay, thank you. Okay, Rebuttal.
Just briefly, Your Honor. I think with respect to the fact that Detective Brown testified that his efforts were before the warrant was introduced, I think that it would have been useless for him to continue calling the same number that he had. The number was out of the TLO system that was supposed to be the good number. He had left messages, I think voicemail and text messages, and there was no response. He had no address that he could do, so there was just no other step he could take. He had already exhausted his efforts before the issue was warranted.
Well, and we seem to have had a lot of these cases recently, and I think that the issue I struggle with is, like, from the state's perspective, when is that sufficient? In other words, to Mr. Hoffman's point, like, do you then need to take another step? And I don't think the case law is crystal clear on that, but he does make the call, so he has done something, which, in some of the cases they've done absolutely nothing, but he's done something that has proved unsuccessful. Do you just stop at that point, or is there any obligation to keep doing something further?
Well, I don't know. Certainly the police officer would be looking for other opportunities to contact Mr. Wilson, and that would be the better practice. But I think for purposes of a speedy trial analysis, that's only one factor. I think with respect to the reason for the delay, that factor, there's no sign that it was deliberate. There's no sign that the state deliberately tried not to serve him. and then you have to balance it with all of the other factors. And I think really it comes down to the prejudice. That's what McDonald says, is that really the constitutional speedy trial provision is mostly about the prejudice to the defendant, and in particular, as far as anxiety and pretrial incarceration, and neither of those factors are there. And those factors weigh very strongly against Mr. Wilson, and I think would probably mitigate any problem with the reason for the delay. Thank you.
All right. Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written opinion. And that concludes argument in the First District this morning. Hope everybody has a great day.
Court of Appeals, First Appellate District of Ohio is now